advocate for the U.S. Army. He's currently a graduate research fellow at the Center for International and Defense Policy, Queen's University, and a graduate student in journalism at Carleton University in Canada. Dr. Cox has been researching the reality of perception during the war in Gaza, looking at the depictions of international law in media coverage at the conflict. We're very happy to have him.
Recording in progress.
Thank you very much. Can you hear me okay? Sound come okay?
Yes.
Okay, great. Thank you for inviting me to join you there. Apologize for the technical difficulties that have put me in the evening rather than earlier this morning, my time anyways. But I'm glad that we're able to connect. I'm keenly aware that the dinner is scheduled to start in 4 minutes, so I will I'll be cognizant certainly of the time as we go on. So I'll go ahead and share my screen so we can begin. All right, so as a retired judge advocate and now a journalism student, I've been really focusing on and studying how international law is portrayed in the media. And what I find is, that there's a saying that I'll talk about here in a bit, that perception is reality. And it's not actually accurate in this case, I don't think. I think it's just that the perception of the general public, because of the factors that I'll talk about throughout the presentation, don't match reality of what the law involving armed conflict actually is. And so the issue of perspective and perception and the connections between those two will be important, kind of central to the presentation. And since perspective is so important, I'll just go ahead and share what forms my perspective and how I perceive international law involving armed conflict. So I'm basically in what I would consider my third career. My first was for 15 years as a combat soldier in the U.S. Army, and then I spent 7 years, that was my first career there on the left of the screen. In the middle, I spent 7 years as a military lawyer before I retired in 2018. And those, including a deployment to Afghanistan as an operational law attorney, which really shaped how I see international law in practice. And so I've taken the experiences from those two careers into my third career now as a law professor, researching and writing about international law, national security, things of that related subjects. I'm not sure what I'm going to do with this. I have an idea, but as a journalism student, I don't think I'll make a fourth career, but certainly it'll augment my third career as a law professor. And so when I am speaking of perception, I think it's helpful to have a sense of what it is that is shaping, the factors that are shaping public perception. And when I present to a military audience, they take for granted that there are 3 levels of command, strategic, operational, and tactical echelons of command. We kind of take for granted that these exist, but what they are is basically a formalized structure to communicate objectives and intent from the strategic down to the tactical. So we have this structure that we kind of take for granted. In the military sphere. In the public space, there isn't this structured hierarchy for echelons of command. But there are, I believe, that it's something I've been studying, still strategic, operational, and tactical levels of objectives and intent in public discourse. And so the strategic is to humanize international law involving armed conflict. And so, actually, I'll back up here. So just to quote from Jean Pictet, who wrote in 1966 about the principles of what he described as international humanitarian law. He regards humanitarianism as a universal social doctrine which aims at the good of all mankind. And so that forms the strategic level of the equivalent strategic level of objectives and intent for humanitarianism in public discourse. And if we move down to that's the strategic level. If we move to the operational level, there's 3 lines of effort that I think we can identify that have kind of coalesced. One of them is to fuse human rights law with law of armed conflict, which we see quite frequently in legal scholarship today. Second line of effort is pluralism, so expanding the community of people who are perceived to be able to interpret and even develop international law. So that's the second line of effort. And then the third really started with Pictet in the mid-60s, the principle of international humanitarian law. You can see there's a series of articles that he wrote in the International Review of the Red Cross in September, October, November of 1966, where he developed what he described as the principles of IHL, which we still have today. It was in a sense, it was an attempt to rebrand law of armed conflict as it existed, as provide an alternative to what states applied in practice. And so this effort of rebranding is still prominent today. And so with the strategic and operational level in place, we can those tools can be used at the tactical level to shape public discourse or public opinion in order to achieve specific objectives, which we can see some of them that are listed there at the tactical level. And it's really, in a sense, attempt to use international law, or at least perceptions of international law, to achieve these objectives. So this is a pretty prominent hashtag that we see very frequently in public discourse, that these things, these categories, these people or objects are not targets. But of course, this is a misinterpretation of international law, because this allows people in public discourse to characterize attacks that otherwise did comply with the law, that did not intentionally direct an attack against a civilian object, to nonetheless, if a civilian object is attacked, to say it was not a target and therefore it was a violation of the law. And so what we'll focus on for this presentation is the tactical level. And I'm going to focus on public perception and how it's shaped in the media. And so I'm going to actually focus for present purposes on one specific story about the World Central Kitchen attack that occurred just over a year ago now. So I'll take a look at how specifically these lines of effort that I described earlier are used and how they show up in this story, and then we'll expand to see how it's applied in related media stories or media coverage of conflict, specifically the conflict in Gaza. And so you can see that the journalist who's writing here, Amanda Tom, who writes for the New York Times, says that the events raise broader questions about how Israel, the IDF, identifies civilians and protects civilians. When in reality, as we'll see, the sense that the law exists to protect civilians is a distortion of international law that has been developed over time. It doesn't match the doctrinal version of the law that we apply actually in practice. And so we'll see the types of experts that Amanda goes to and their commentary, and how this distorts international law, and how that ends up shaping public perception of military operations. So the first one here is this claim that the most basic principle of IHL, or the law of conflict, is that civilians can't be targeted. So this is actually let me skip past that one for a second. Let me go to the next one for cases of doubt. So this is very a common claim in public discourse, that in cases of doubt you can't attack. So this is a misrepresentation of IHL or LOAC. It's referring to AP1, Additional Protocol 1, that does have a provision that says in case of doubt for a civilian object, you should presume that it's presume that it's civilian. That doesn't apply to personnel, to people. And there's a question as to whether this is actually a representation of customary law. So this is something that I've covered in my scholarship, and the concern, one of the concerns that I've raised is that it encourages, by saying that there was a presumption of civilian status, it encourages a post hoc or an ex post assessment of whether an attack complied with law of armed conflict. And so the actual law, so this is drawn from the Rome Statute. Of course, Israel has not ratified the Rome Statute, but this is consistent with the doctrine of the IDF. And the U.S. military, incidentally, there's also not ratified the Rome Statute. The actual law is that it's a violation of the distinction rule to intentionally direct an attack against the civilian population, right? Rather than targeting the civilian population. So targeting the civilian population ends up encouraging, and again, an ex post assessment of whether the law is complied with, because we're looking at the aftermath and saying, well, you targeted this person, this object, rather than actually articulating what the law is, which is you intentionally directed your attack against a civilian person or a civilian object. And so this is one way that, in this story, that international law is distorted by the expert commentary that Amanda Taub has asked to provide, the expert that Amanda Taub has asked to provide commentary. And then Tom Denenbaum also notes that it's a war crime to recklessly attack a civilian person or object. This is something I've also addressed in my legal research and writing. You can see there's the title of the article. That was my first one that I had published. So this is something that I've studied, and that's actually not the case that war crimes, that recklessness is included on the spectrum of intent for war crimes doctrinally. It's just not how international law works for the Rome Statute or how militaries apply international law in practice. But there's a sense that if an attack was committed recklessly, that it could also be a war crime. Here's Nina Dill also providing commentary, saying that, again, humanitarians are supposed to be protected and that they're supposed to be presumed to be civilians, which again also encourages an ex post assessment of whether the law is complied with, rather than looking what the law actually is and asking, did the personnel responsible for the attack intentionally direct the attack against the civilian population, which means they knowingly and not accidentally directed their attack against the civilian population. And so what we end up with is an assessment, a claim that this strongly indicates that there is a violation of IHL, that there provides a clear reason that it should be investigated as a war crime, when throughout the entire article that we've just looked at, and it's just kind of excerpts, of course, but throughout the entire article, there's not once an articulation of what the law actually is that we apply in practice. So part of the way that we get there, part of how international law is, it's misrepresented in this way in public discourse, is, of course, the experts that we end up going to ask for expert commentary in the media. So Tom Denenbaum has not been in the military. Nina Dill hasn't either, nor does she have a law degree. Neither one of these experts they're experts in something, certainly, but neither one of them would be qualified to provide advice to a commander on an operations center floor, or to advise an investigator afterwards. And yet, these are the experts that the media ends up turning to provide expert commentary on events that actually occur during armed conflict. And so this brings up this sense of pluralism, right? So expanding the community of people who are perceived to be able to interpret and even at times create international law. So this is commentary that's drawn from a blog post from a friend of mine, Thomas Wheatley, who attended a conference in Cambridge a while back, and he said he was talking to humanitarian advocates and military personnel. And he said there's a sense among us that these two communities of practice are now more unalike than we are alike. And this part of the reason why this exists, this sense, is the version of the law that's applied in humanitarian space doesn't match the version of law that we apply in practice, in doctrine. And so the way that this ends up shaping public perception is we believe as journalists that we're engaging in our work for the public good, but there are a few shortcomings for our profession that end up prohibiting us from actually presenting fair and balanced and informed media coverage, and we end up not being able to serve the public good in the way that we think. So one of the concerns, one of the limitations is we are not expected as journalists to be experts in the subject matters that we write about, and so we end up going to seek expert opinion to provide commentary. But when we do this, we end up exercising our own personal biases for the experts that we end up seeking out, and they provide basic commentary that we're hoping to hear and we're hoping to communicate to our audiences. And so we end up conveying a distorted version of law of armed conflict potentially without even recognizing that we are. And so I've taken this picture. This is a big mural that's in my journalism school at Carleton. So we think that we're here to do accountability and fairness and transparency and convey truth and accuracy in our reporting. But these limitations that we very often don't even recognize that we have end up infringing on our ability to do that. And so this is just one story that I looked at in the New York Times about this one attack. But if we expand this analysis, we could apply what I just talked about to other stories about this specific attack in other news outlets. And then if we expand past the World Central Kitchen attack specifically, we can look at, we can apply those same principles I just talked about to other media coverage. So this is the Kabul drone strike, the series that won the Pulitzer Prize for the New York Times not long ago, Airstrikes Gone Wrong, the coverage of the attack on the MSF Trauma Center in Kunduz in 2015. All of these stories, if we look at each one, end up displaying a lot of the same limitations that I've just described. And so it's not necessarily the case, again, that perception creates reality. I think in this case, the law stays the same. The doctrinal law that we apply in practice doesn't change. It's just the public perception of what that law is and how it applies doesn't match the reality. And part of the reason why that is so you can see here the three operational lines of effort in humanitarianism: using law of armed conflict, human rights law, encouraging pluralism, and rebranding international law is not something that we can do in practice, but it's something that's routinely done in the public space, and then the media picks up on that, and then it ends up shaping public opinion and essentially public policy as well. So I'll close on a quote from Harold Koh that he offered in a Brookings Institute speech in 2017 that I think really sticks with me, and I think it's really important to emphasize. So he described, if he's right about this, and I think he is, he described law of armed conflict as the most discussed but perhaps least understood body of transnational public law. And if he's right about that, again, which I think he is, that has a significant impact on our ability to effectively engage with the law of armed conflict in public discourse. If we talk about it so much, but it's not understood as well as it should be, then that ends up eroding the quality or the effectiveness of the discussions that we have and the public opinion involved in the application of international law. And so one of the ways to improve understanding is to host forums like these, and so this conference. And so I commend everyone for the organizers for hosting this, and the presenters and the attendees. We in this process are helping to make international law more understood, and I think along the way we'll end up improving the discourse, the level of discourse, the effectiveness of discourse in the public understanding involving law and conflict as it applies in practice. All right, so with that, I welcome any discussion or questions you may have, recognizing that that the conference center has by the schedule at least started 15 minutes ago. But if anyone does want to reach out at some point, this is my primary email address, so feel free to email me really at any time. All right. So
do you hear me?
Yes, I can.
Thank you very much, Brian. Your presentation fits in very well with things that we've discussed already at this conference. I'm going to open up if the audience has any questions. They are welcome to come here to ask questions directly. Okay, sorry. Okay, so I will ask. Andrew Fox at the beginning of the conference, he spoke about the basic, let's say, the fact law of armed conflict is essentially the laws of legalized killing, and morally, right? It's counterintuitive in the sense that the average person, when they see, right, these images of people dying, right, they feel this is wrong, and their automatic intuition or reaction is to say, right, these civilians died, this must be wrong. So besides, let's say expert panels, expert discussions, what is another way to push back on essentially the counterintuitive nature of what LOAC is?
Yeah, I think that's a really excellent point that Andrew made and that you raised. It's just human nature to see images of this, or to be there in conflict, and be moved by the human suffering that that is inflicted. Regardless of who's right and who's wrong, regardless of who started a conflict, it involves an immense amount of human suffering and tragedy. My concern is that this wasn't always the case. It wasn't always the case that the law was used in a way to describe what we experienced in conflict. But over the last, say, it's been happening for the last 40 or 50 years, but now it's so common to express, public outrage, or the sentiments that we experience when we see or engage with what the human suffering in our conflict, to use legal language to do this, and it doesn't have to be experts that push back against these narratives. But what I encourage is, everyone who is involved, everyone who has a stake in public perception, has to be, if you're not already there, you have to be trained to see the law as an operator does, as the ILD does in the MAG Corps, right? Because they are the ones who are advising the operational client who's actually out there, engaging in armed conflict. And so, if my biggest takeaway is that it's one thing to know what the law is, which is vitally important. You can't advise, you can't perceive the law in the same way that the International Law Division does, or department does for the MAG Corps, without a deep knowledge of the law. But it's also, we have to be able to see the law as it applies through the eyes of an operator. Because those are the ones who are engaging in armed conflict, those are the ones who are advising the commanders who are actually applying this law in practice. And public perception will not match that reality. But the more that we see the law in the way that an operator does, the more that we can communicate, because operators aren't out here. It's very, very rare that you hear in public from an actual operator, but we are communicating internally to our client, our military client. For those of us who are now engaged in public discourse, we have to see the world in that way and articulate it in that way.
All right. Thank you very much. Thank you very much for your presentation. Thank you. And thank you to all of our attendees.